First of all, I'd like to welcome everybody. I'm ecstatic at the crowd. Thanks for coming out tonight. I'd like to start out by recognizing that we're on the unceded territory of the Wissquaquet and Mi'kmaq people. I'd like to thank them for sharing their land and their wisdom with us. My name is Tom Beckley. I'm a professor in Forestry and Environmental Management, and our faculty is very proud to sponsor our guest speaker this evening. I also want to acknowledge that we're doing this with a grant from the Post-Secondary Education, Training and Labor Department of the New Brunswick government. These are exciting times in our university community, and I think in Canadian society as well, with regard to the real serious work that needs to be done with regard to reconciliation with Indigenous peoples. And I think tonight will go some distance toward helping that. We for sure have a long way to go, but I feel there's a new and positive mood, and I'm feeling quite hopeful. I hope you're feeling hopeful as well. That said, I've been feeling hopeful since 1994 when I first met Peggy around a table with, sponsored by the Canadian Council of Forest Ministers, where we were supposed to come up with criterion indicators for sustainable forest management. I was the year out of grad school, and I was the social guy. Peggy was the Aboriginal representative, and so all the foresters were looking at us like, what are they doing? So anyway, we had some good times and conspired and raised a little stink every now and again, and I think Peggy's been raising stink ever since in good ways. So here's the formal part. Dr. Peggy Smith is Professor Emeritus from the Faculty of Natural Resources Management at Lakehead University in Thunder Bay. 30 minutes ago, she was at 30,000 feet on a very long, arduous adventure to get here, but she made it. Peggy's also known as Misquanaquaduk, or Red Cloud Woman. Is of Cree ancestry from the James Bay Treaty 9 area. She was appointed Interim Vice-Provost of Aboriginal Initiatives in September of 2016 and held that position until she retired last fall. She's a registered professional forester with Ontario Professional Forestry Association, and she's taught policy and legislation in natural resources, environmental assessment, Aboriginal peoples, and natural resources development, Aboriginal peoples, and her research covers social impacts of natural resource management, especially Indigenous peoples' rights, community forestry, public participation, urban development, and forest certification. Peggy continues to be affiliated with the National Aboriginal Forestry Association as a senior advisor. And in recent years, she's also been very active with the Forest Stewardship Council, nationally and internationally. And recently, she was also appointed to the board of the NGO Rights and Resources Group. Tonight, Dr. Smith will be speaking on Beyond the Duty to Consult, Free, Prior, and Informed Consent. So please help me welcome Dr. Peggy Smith.
To dual duty, and rather than being turned over to the screen, I'm just wondering if there's an easier way to set that up. Can we put it right there? Okay, great. That's good.
And let me take that out for you. So it's just this, that should come right out there, and you just use your cords there.
That's good. So I'm thankful and grateful to be here. I left Thunder Bay yesterday to come here hoping I would be here overnight and be relaxed and settled in, but my flight got postponed and I wasn't able to make the connection, so I was up at 4:30 this morning and caught a flight at 6:18 and then got bumped in Toronto and had to sit for 5.5 hours in the Toronto airport. So let me just get rid of all that stuff and try and be focused and present. So yes, I'm glad after all of that I actually made it here. And I'm very thankful that you all came out. We are in interesting times. There have been lots of changes going on in terms of the relationship with Indigenous peoples, and I've been at this for 30-some years now, and sometimes I think that nothing's changed, And then other times I look at what's going on and I think, oh, maybe there's some hope here that things will actually shift to a different place. And I guess particularly after the Truth and Reconciliation Commission, we've all been grappling with this question of how do we get on a different footing in our relationship. So I'm going to look tonight at what's happened with the duty to consult and how we've moved forward with free, prior, and informed consent, and really asking the question, have we moved forward with this concept of free, prior, and informed consent? And I'm going to, let me just, and I left my, my glasses off, but I'll do without them. So again, I thank Tom for doing the traditional land acknowledgement. I'd like to also acknowledge that we're on the traditional territory of the Mi'kmaq and Maliseet. And also, coming from Northern Ontario, we're in an area where we have historic treaties. Those historic treaties were begun in 1850, and they started with the Robinson treaties along Lake Superior and Lake Huron. And the model for those historic treaties was about ceding lands and resources in exchange for a guarantee that Indigenous peoples would be able to continue their way of life. And that they would be able to do that on unoccupied Crown land. And that language in the historic treaties has meant, in where I come from, that Indigenous peoples have literally been pushed aside onto reserves. All of the Crown land, even though we might not have thought it was possible in 1850, all the Crown land is now occupied. It's under ownership privately, it's still under Crown control, and it's been developed over the last couple of hundred years for the rich natural resources in the area. The same thing has literally happened here, but the treaties that Mi'kmaq and Maliseet entered into were not about ceding lands and resources. They were about establishing alliances and peace and friendship treaties. They did not cede any of the Mi'kmaq and Maliseet land, but that didn't stop colonizers from taking over that land, and essentially Indigenous peoples in New Brunswick have been as marginalized and pushed aside from their territories as Indigenous peoples in historic treaty areas. But it is a difference in the relationship, and it's probably an important one, an important distinction to understand, but I think it's more important to focus on what the common elements are in terms of the broader relationship between Canada and Indigenous peoples. So I'm going to look at what we've developed in terms of consultation with Indigenous peoples around resource development. And then I'm going to move into looking at the concept of free, prior, and informed consent that's been enshrined in the UN Declaration on the Rights of Indigenous Peoples. And then explore the question whether free, prior, and informed consent is actually a step forward. So how are we doing things now? We're dealing in a relationship between Indigenous peoples and what's called the Crown. Initially, the Crown, of course, was the Queen or the King of England, but the Crown has now become those folks to whom the Queen delegated her authority, and that initially was the federal government of Canada, the government of Canada, and the provinces. And for a long time, Indigenous relationships were largely with the federal government. So we have a situation where our Constitution gives authority for the government of Canada for Indians and lands reserved for Indians to the federal government, and authority for the management of natural resources to the provinces. And so we have a major issue because federal and provincial governments have failed to take responsibility for their trust relationship with Indigenous peoples when it comes to Indigenous interests in lands and resources. It's been a passing the buck that's been going on for ever since 1867 when we became a country and the Constitution was authorized. So that dilemma has been changed over time, triggered by the repatriation of the Canadian Constitution in 1982. So in 1982, we had Pierre Trudeau brought the Constitution back to Canada, had renegotiated it, and Indigenous peoples at the time fought for a voice and a place at the table in those constitutional negotiations. And as a result of that, they won a section in the Constitution that acknowledged Aboriginal and treaty rights. And I think we were the first country in the world to constitutionally recognize the unique place of Indigenous peoples within our country. And as of 1982, it has been largely the Supreme Court of Canada that has taken us out of our colonial relationships and turned us onto this different path that we're on. So I want to look a little bit at what the courts have said about this consultation that's required now in natural resources. So that duty is to consult and accommodate through what's called meaningful consultation, and I'll talk about what that is, to minimize the infringement of Aboriginal and treaty rights that are recognized in Section 35 of the Constitution Act when resource development is proposed. So I'm not going to go through all of these cases, but just to give you a flavor and to emphasize how important these Supreme Court of Canada decisions have been in changing the relationship. I mentioned that the Constitution Act in 1982 acknowledged Aboriginal and treaty rights, but there was a case just before that in 1973 that I think was the trigger for Pierre Elliott Trudeau to acknowledge that Indigenous peoples had a unique place in the country. Prior to that, he didn't want to recognize that there was that distinction, and in his idea of a just society, we were all to be equal. However, the Calder case in 1973 recognized this concept of Aboriginal title, and that was that Indigenous peoples own the land. They have a unique form of ownership of land that's particular only to Indigenous peoples, and that there has to be an intent to extinguish their ownership by the Crown before any resource development can occur. So this case was brought forward by the Nisga'a, who have since gone on to negotiate a modern-day land claim that was ratified in 2000 in British Columbia. It was the first modern-day treaty in British Columbia that, for large part, had not entered into any kinds of agreements or treaties with the Crown. So that Calder case was really important in bringing Section 35 into the Constitution Act. And then we have a whole series of cases that go on to define what Aboriginal and treaty rights are. Constitution Act, Section 35 just says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada, defined as Inuit, Indians, and Métis, will be acknowledged, and I'm trying to remember the other word that's in the Constitution, but it doesn't matter, that those rights will be acknowledged. And that's all it said. So what did that mean? Nobody knew what it meant in 1982, and it then became the Supreme Court of Canada's duty to start to define this. Provincial governments didn't define it, federal governments wouldn't define it, and so it was Indigenous people that brought these cases to the courts asking for clarification about what their rights meant, what the Section 35 rights meant. So these cases start in 1990 with the Sparrow decision, and it was the fisheries case in British Columbia. Musqueam Ron Sparrow, who had been fishing using traditional methods, and he was charged with fishing improperly under the Fisheries Act, which is a federal piece of legislation, and he argued that it was his right, his Aboriginal right, to carry on fishing as he had done traditionally. The Supreme Court of Canada acknowledged that, and so we start to get this sense from the Supreme Court about what these Aboriginal and treaty rights are. Over time, what that came to mean was that they were based on historic land use and occupancy, and unless they had been relinquished in an agreement with the Crown, they continued to exist. Delgamuukw in 1997 was really important because that was the case that acknowledged that the Crown, before they took any effort to extinguish Aboriginal and treaty rights, had a duty to consult, to understand the rights, and to ensure that they were minimally infringed, and to ensure that any infringement was justified. So Delgamuukw was a central case. I put Powley in here. I'm putting Marshall in here as well. You're probably all familiar with the Donald Marshall decision, where he had exercised a treaty right to fish eel, and it was upheld in the court, and the Supreme Court of Canada went on to say that not only did he have a treaty right to fish, he had a right to earn a moderate livelihood. So there was a commercial element to the rights. And of course, that triggered lobster wars in the East Coast. It triggered discussions about how Indigenous peoples were going to be brought back into the fisheries that had traditionally been theirs. And hopefully those things have not entirely resolved themselves, but have settled down somewhat. And there are relationships and being worked out around those rights here. I mentioned the Powley decision because it's a decision that recognized Métis rights, and it was the first decision to do that, and that was recognizing a Métis right to hunt. The Haida case was really important because it clarified who had the duty to consult. Now, it was another British Columbia case where the Haida challenged a transfer of a forestry license from McMillan Bloedel to Weyerhaeuser, saying that neither the company nor the province of BC had consulted with the Haida, who had an Aboriginal title claim to that territory where the forestry was taking place. So the Haida decision clarified that the duty to consult rests with the Crown and not with the private sector, although the private sector does have some obligations, and the Crown can delegate procedural aspects of consultation, which has also opened up a whole can of worms that is still being figured out. The Mikisew case was really important in 2005 because most of these cases up to this point had been in British Columbia where there were no agreements with the Crown. So in places where there were historic treaties or peace and friendship treaties, like in the East, those provinces would say, the decisions in British Columbia don't have anything to do with us because we've got these agreements, and through these agreements, Indigenous peoples have given up all their rights. So if they signed a historic treaty, they ceded all their lands and resources, the sole authority for resource development rests with the province. So 2005, the Supreme Court of Canada said, no, that's not the case, that provinces where there are historic treaties have the same duty to consult to ensure that they do not infringe the treaty rights that they have agreed to, which are largely, again, guaranteeing that Indigenous peoples are able to continue their way of life based on historic land use, hunting, fishing, trapping, and gathering. And then recently, we've had a couple of groundbreaking decisions. Tsilhqot'in from British Columbia is the first case in Canada where Aboriginal title has been recognized, of a particular First Nation has been recognized. So if you go back and remember, 1973, with the Calder case, Aboriginal title is recognized, but the court didn't recognize the Nisga's title. They just recognized the concept. So whatever, 30, 40 years later, the Supreme Court of Canada, in the Tsilhqot'in decision, acknowledges that the Tsilhqot'in have not given up their rights and that they continue to have that Aboriginal title or unique ownership of their territory, and before any resource development occurs, their consent is required. So this was a major shift, and it's a link between the old way of consultation and the new way that we're moving forward to, where we're actually seeking Indigenous people's consent before resource development occurs. In Ontario, Grassy Narrows was really important because Grassy Narrows wanted to clarify who was responsible for forest management. They claimed that it should be the federal government that authorizes the provinces to do forest management if their rights were going to be infringed. And the Supreme Court of Canada ruled against them and said that's not the case. Constitutionally, it's the provinces, and it's clear it's the provinces, have the responsibility for natural resource development. But the court reasserted in that situation, the provinces have that duty to consult to ensure that Aboriginal and treaty rights are not infringed. So it clarified for the province of Ontario, at least, and any other province where there are historic treaties, that those provinces do have that duty to consult. Mind you, Mikisew had already been clear about that, but Grassy Narrows just reaffirmed it. So let's look at some of these legal principles that have been agreed to through these Supreme Court of Canada decisions. We have this Aboriginal title. Again, it's a legal right of ownership, and it's based on historic occupation and land use. Now, it may look like the Supreme Court of Canada is siding with Indigenous peoples, but I want to clarify that a lot of these decisions are very restrictive when it comes to interpreting Aboriginal and treaty rights. So, for example, for historic occupation and land use, the onus is on Indigenous communities to prove that occupation and land use. So you'll find a lot of First Nation communities are doing things like traditional land use and occupancy studies these days. One of the reasons they're doing that is because there is this requirement by the Supreme Court that they prove their rights in court. Rather than accepting or basing it on oral tradition and historical knowledge, the courts have actually said that Indigenous peoples have to go to court to prove their rights. Mind you, the duty to consult still exists, even if the rights haven't been proven. It's enough for a community to assert a right. So we've talked about the rights being recognized in the Constitution Act, that it's the Crown that has the obligation to uphold those rights. And over, the Supreme Court of Canada has talked about this principle of the honor of the Crown. And the honor of the Crown principle comes from the Royal Proclamation of 1763, where the British Crown acknowledged that Indigenous peoples occupied the land in what became Canada, and that before any settlement or resource development could occur, it was an obligation of the Crown to enter into negotiations with Indigenous peoples to ensure that there was a peaceful settlement, and rather than what they would call sharp or shady dealings, which were going on at the time. So the other part of the rights is that in Sparrow, what the court said was Aboriginal peoples have a prior right to use the resource over other people, subject to conservation. Conservation comes first, Aboriginal people's use comes second, and then all others. But you have to understand what difficulties that raises in a climate where for years Indigenous peoples have been excluded from natural resource use, whether it's forestry or mining or fisheries, and there has been a whole system structured around giving other people access, tenure systems, use rights, laws that have been put in place, licensing. And so this Aboriginal priority use is still, I don't think, recognized the way the Supreme Court of Canada meant it to be recognized in Sparrow. I've said that rights and title have to be proven in court. Delgamuukw said finally that oral history was to be allowed as evidence in court. Prior to that time in 1997, oral evidence by for example, elders from communities who would come and testify about what they remembered about how they used the land was not considered sufficient evidence in a court of law. Delgamuukw overturned that and said oral testimony will be allowed. So these rights, Aboriginal and treaty rights, are not, the court doesn't consider them sacrosanct, so they can be infringed by the Crown, but they have to be infringed minimally. That is, they wholesale cannot be wiped out, and those rights have to be justified. The infringement of those rights has to be justified. And involved with that is what's called accommodation. So that accommodation could be, if the Crown is going to infringe on the rights, say, for example, the province is logging in an area and it's going to remove tree cover on someone's trap line, and in a lot of cases, in the boreal in particular, it isn't just some cover, it could be the entire trap line is logged over. And so the Crown would be required to discuss with the trappers how they're going to accommodate or compensate for the loss of that trapping. And so this idea of accommodation, which can be financial, but it could also be substituting land in another place for the land that's lost through whatever activity is taking place. The assertion of title is sufficient, as I mentioned, to trigger the duty to consult. It doesn't have to be proven. And rights involve both recognition and reconciliation. So there's a big discussion going on. Does anybody want to give me your take on what reconciliation is? We're talking about it all the time these days. What's it mean to you? Anybody? Anybody? Yeah?
Repairing the relationship between Aboriginals and non-Aboriginals.
Okay, repairing a relationship. Can you say a little bit more? What's involved in repairing a relationship? I always think about couples when I think about reconciliation.
Recognizing the wrongs that have been committed and attempting to make it right, or develop a process that can make it right.
Right.
Or start to.
And those are some really important points that you bring up, because recognizing the wrongs that have been done. Some people think reconciliation is a process where you just get over it and get on with it. That's all in the past. It's done. It's finished. Let's move on. You know, why are we dwelling there? But if you think about reconciliation in terms of even, especially if you think about it in terms of couples, you've probably all been in this situation where you've had to go through a process of trying to figure out how to get back together, amend the wrongs that have been done, and begin or try and renew that relationship. And that's not an easy task, and it doesn't always work. So we need to be patient about this idea of reconciliation and not expect that it's going to be something that happens overnight. But certainly it means understanding different points of view, respecting those points of view, understanding the role that the parties have played in the relationship and what needs to change in those roles. So the courts have constantly stressed, even though we've had these myriad of decisions, they don't like these cases coming to the Supreme Court. They constantly say, negotiate, go back, talk to each other, figure it out. Don't bring these cases to us. These aren't the kinds of things that should be settled in a court of law. They need to be settled between the parties that are involved. So get together and start talking. And so negotiation in this situation is really important. And there's the idea of, some people will talk about rights being historic rather than generative. And historic meaning that they're trapped in time, that they, indigenous rights based on hunting, fishing, trapping, and gathering had to do with people using bows and arrows and traveling in canoes. And some people will say, well, we've got this modern day society now where there's snowmobiles and there's rifles and there are all these things. These rights shouldn't apply now. And the courts have said, no, the rights continue to exist. They're based on historic use, but they have to be translated into a contemporary setting. And they will continue in that contemporary setting. We cannot put Indigenous peoples in the box of forcing them to use tools that came about, in 500 years ago. And so rights should be interpreted in a contemporary context. And if you want to stop me at any time, please, and you have a question, please feel free to do that. So what is meaningful consultation? This is a term that comes from the Supreme Court of Canada, and it has been further and further defined through all of these cases that we've looked at. So again, it's that infringement of rights will be minimal and justified, that there will be proper notice given. It's not that a development project occurs and then you go to the Indigenous community and say, oh, by the way, we built a dam down the road and we just wanted to let you know about that. So it's the idea of prior information, notice, sufficient information so that the Indigenous communities can understand the full implications of that development and the potential impact on their rights. Reasonable discussion, that negotiation that I was talking about earlier, and adequate consideration of alternatives. So the Crown has to be open to hearing what else they might do. Too often the plans are developed, they are set in stone, and they are delivered to Indigenous communities, and those communities are invited to comment on an established plan, rather than starting the discussion from the beginning and saying, we have interests in mining in this area. We're beginning to explore that. Thanks, Tom. We're beginning to explore the potential. We want to begin that discussion with you about what your particular concerns and issues might be before any of that development occurs. Our respect for different knowledge and values. So I'm not talking a lot today about Indigenous values and knowledge, but there is a different way of looking at the world. Yes?
Whose definition of meaningful consultation is this?
It's the Supreme Court's. And you'll find you have to read through a lot of the cases but others, lawyers, have summarized these elements of meaningful consultation that the Supreme Court has come up with. One particular one I think that was key in putting some meat on what meaningful is was the Halfway River First Nation case in British Columbia, where the court explicitly listed some of these things. So, for example, consultation can occur, there's a lawyer, Bruce McIver, calls it drive-by consultation. So that drive-by consultation means you phone the band office, and if you don't get an answer, you try a second or a third time, and you try to set up a meeting if you're frustrated and it doesn't happen the way you want it to, and then you just drop it and say, well, we tried. So in a lot of the court cases, what happens is that the proponents, whether it's a company or the province, has to actually document the efforts that they made to contact the First Nation and to show that contact.
Wants to do a reschedule.
No.
See, no. Reschedule.
It's a good thing I don't have my glasses on. I can't even.
Now. God, let me. I'll
Okay.
do it.
Okay, you do it. Yeah, much later. I gotta stop fiddling with my earring.
Okay. That should save us. No, it did not. 10 p.m. Am I just doing this maybe? Yes. Unbelievable. Okay.
So in drive-by consultation, a lot of times the real effort isn't made to contact the First Nation. And it's an issue because Indigenous communities have issues of capacity. That is the ability to respond to numerous requests from the Crown. In British Columbia, they call them referrals. I don't know what they're called here. Ontario goes through a process through different departments where they will contact First Nations. And there can be multiple requests on multiple development issues in a band office where you've got, if you're lucky, one lands and resources person. And a lot of bands wouldn't even have a lands and resources person. So coming up with a system where you actually are able to give proper notice, provide sufficient time, give sufficient information, even provide some of the funding that's required for Indigenous communities to hire technicians so that they can properly respond to what are often very complex issues. If you think, anybody been involved in an environmental assessment? For simple process, right? Oh, yeah?
Oh, big day today.
Oh, I'll have to hear about this. What happened?
Well, they eliminated the National Energy Board.
I hadn't heard.
And created an impact assessment agency for one-stop shopping on environmental assessment. And basically institutionalized.
Consultation. Yes.
How long has this definition been?
I mean, in use.
Well, it began with the Supreme Court of Canada decisions in 1990 with Sparrow. That was the beginning of it. Halfway River, I think, was the mid-90s.
This has been followed for the last...
Oh, no. Okay, that's coming. No. This is, I don't know, I wouldn't call it theory, but this is policy. This is Supreme Court of Canada decisions. And now whether the provinces have followed this guidance is another question, which is what we're going to talk about next. Yeah. Okay, so another thing is that there is a range of responses from depending on the extent of the infringement of Aboriginal and treaty rights. And that range goes from simple information disclosure, if the infringement is going to be minimal. For example, if they're putting in, if there's some logging going on in an area and they're going to put in a removable bridge over a stream that may have an impact on fisheries, you might see that as being something that would be in a minimal infringement of rights. And so it might be simple information disclosure, all the way to extreme infringement of rights, the one that I mentioned earlier with logging, for example, where an entire trap line is removed, and would be removed for a period of 30 to 50 years before there was regrowth, right? So that might be seen as an extreme infringement that could be seen to require the consent of the Indigenous people that are involved. That's what the Supreme Court calls deep consultation. But the other part of that is it's based on the strength of claim. So the strength of claim has to do with if you have Aboriginal title, that is, you haven't entered into an agreement with the Crown, a treaty, with historic treaties where you ceded lands and resources, or even the peace and friendship treaties where you have some defined rights and ways of relating under the treaty. If it's Aboriginal title and you haven't entered into an agreement with the Crown, you have a stronger claim, according to the Supreme Court, than those who have agreements with the Crown. So the Supreme Court will weigh the strength of claim and the extent of infringement when they look at this range of whether it's simple disclosure through to consent. Did I see a hand up? Yeah?
We kind of have a situation about somewhere along the lines because when you're looking at First Nation governments, mainstream doesn't really know. That's just another extension of the federal government. It's not an original government. So when you're looking at the unceded territories, I'll use the Gaspé region because that's where I'm from. They have three communities, Listugush, Gespegawagi, Gespegia, and Gespeg. Now, within those three communities, they created another entity similar to what all three bands put together. So when it came to duty to consult, they were only consulting them. They started their fracking up there in the Gaspé area, and nobody knew about it. The province of Quebec was issuing licenses left and right, and without consultation. But in their eyes, they saw that maybe because we funded these organizations, that was part of the duty to consult, but they weren't consulting the people. And I think that's where a lot of people seem to be misled, because it's actually the people that are supposed to have this better understanding prior to anything starting. And we don't see that.
Yeah, and that's a tough topic, and there are even some court cases around that as well, where you have family members or a family group that has challenged the decision of a band chief and council on the basis that their family trap line, in British Columbia they call them KOs, that their trapping was being infringed on by an activity, but they were never consulted about it, but the chief and council were consulted. And so, but the court in that case ruled that it's the chief and council that have the authority to address the issue of rights.
It might be a little different on this side.
Yeah,
Because
yeah.
the treaties, when you're looking at treaties, are much older than you move on past out to Ontario. Like in 1752, the peace and friendship treaties was all about sharing. So that's why when you talk about you're on unceded territory, it's really unceded territory.
Yeah.
There was no ill meaning in terms of we're here to share. There's not a problem with that. But what happened along the line is that the governance system had changed. And I think
The indigenous governance
yes,
system.
the indigenous government had changed, although it's still recognized. Within Mi'kmaq territory, you're looking at 7 districts between all of Gaspé right down to Nova Scotia. And they still fall under that district. The only issue we have right now, I think we have one of our original district chiefs actually gone to the Superior Court of Quebec, and the judge recommended that what you need to validate your case was that if you had majority of the people within your community, amount of names, I'll use round numbers, let's say we have 1,000 people in the community. The chief was elected and he only had 300 votes. But if he had 400 people from the community stating that, yeah, we recognize you, that overturns that automatically. But these aren't really seen too often in the Supreme Court decisions.
Yeah.
So again, it's a little misleading in terms of the legalities.
It's complicated.
It is.
Yeah. And we're going to, after the next slide, I want to carry on the discussion and hear more about what's actually happening here and what people think about what's going on with consultation. But let me finish the one slide and we can come back to it. So the final thing is the meaningful consultation requires reconciling provincial policies and programs with Aboriginal and treaty rights. So the courts are fairly clear. They acknowledge that the provinces have this responsibility to manage natural resources in the best interests of the entire population, but they also have a responsibility to uphold Aboriginal and treaty rights, and that's a balancing act. And so they're going to consider how well the province has done that in addressing these rights. And again, when I said, sometimes it looks like the Supreme Court may be supportive of Aboriginal issues, but here it does, in some of these cases, it hasn't taken much to justify infringement in terms of the greater good. So, and I think it's the same case, the Halfway River First Nation case, that talks about the province having the right to infringe natural resources in order to mine, do logging, build dams, and bring in migrant workers to do major development projects. So there's a whole list there that the Supreme Court has accepted as being justification for infringing Aboriginal and treaty rights. So I'm not really familiar with the New Brunswick consultation policy, but I did have a quick look at it. And it's similar to what's in place now in most provinces across Canada. And you can see from the policy that it's very much in response to the Supreme Court of Canada decisions. That is the province upholding their duty to consult. So they acknowledge that they need to consult with First Nations before any action or decision that may adversely affect Aboriginal and treaty rights. Those rights they define as hunting, trapping, fishing, gathering, and other traditional uses associated with ceremonial activities and culturally significant sites. And some of the triggers that they list are regulations, policies, plans, procedures, resource management, Crown land management, land use, and environmental regulation. And I didn't mention it in the Supreme Court of Canada decisions, but one of the things that the Supreme Court of Canada has said that consultation is required not just for operational decisions, like where you're going to log or where you're going to put in a mine, but for strategic decisions as well. And those are the higher level policy decisions that may have an effect on Aboriginal and treaty rights. And there are a list of goals or principles by which the province operates on consultation, including integrity and good faith, respect and acknowledgement that it is government's duty to consult, reciprocal responsibility. That means, and the Supreme Court of Canada has said this over and over again, First Nations do not have a right to refuse to consult unless they feel that the consultation procedures are unfair. So it is that if the Crown comes to an Indigenous community with a consultation request, that community cannot just say no. If they expect later on to go to court to challenge it, and it's been found that they haven't entered into a consultation process, then the court's going to take that into consideration. Transparency and accountability, and finally this balance between the responsibility the province has for the greater population and the responsibility it has to uphold Aboriginal and treaty rights. Now, sometimes people may see those as being in contradiction, and I don't. My thinking on it is it's not really contradictory. I don't see many cases where upholding Aboriginal and treaty rights goes against the greater good. In fact, a lot of times upholding Aboriginal and treaty rights will enhance the greater good, because a lot of times those rights have to do about environmental protection, about using the land in a certain way, about ensuring that there is equity and fairness with Indigenous communities. So I don't, it's the same issue that comes up in terms of consent. People will often talk about consent in terms of veto. Oh no, we cannot give Indigenous peoples a veto over resource development or we're going to be held hostage. And that is not what this whole consultation and consent process is about. So, your observations on how the system is working right now in terms of consultation. Yes?
I had a question in response to the Supreme Court decision on that too. Wouldn't the United Nations Declaration on the Rights of Indigenous People, as good as those Supreme Court decisions are, at the end of the day, those are settler interpretations of Indigenous treaty rights, whereas if you look at some of the early sections, especially I think it's like the third one in 1800, where Indigenous people have the right to reproduce, revitalize traditional economic, education, these type, which would get back to a gentleman from Listigish here, his response about traditional governance. We have the right to repair our traditional governance. So where does UNDRIP fit in with all this, which I would think gives more self-determination and sovereignty, and I would also say, in some cases, a direct right to veto.
You're going to have to hold that thought. We're going to talk about that, but let's stick with the consultation part right now. And then we'll move on to Interim. Okay, and those are really good points. But there are issues there. Yes?
In your historical explanation, what is the position in this relationship with First Nation with the Bay James Treaty? Because it was the first time a big treaty happened between First Nation and the province for resource development. The Bay James Treaty, well before 1973, I think it was 1970, it was with the dams, the Hydro-Québec dams. And the other things also, I want to know also what is the impact also of the creation of Nunavut? Because in 1999, you have a big shift there when the creation of a territory for Inuit. So these are two events has an impact on all the relationship between First Nation and non-First Nation people.
My hearing isn't all that great, and so I'm not sure I caught the question.
During the last, I would say, 40, 50 years, there were two major things happen. One is the Bay James Treaty for the Hydro-Québec Dam, and this was presented as an example of good treaty for resource development.
Yeah.
And the second is in 1999, the creation of Nunavut.
Yeah.
I have the chance to travel in Nunavut, and I see that the relationship between Inuit and non-Aboriginal people are completely different in Nunavut. So I have your opinion about these two events on all these stories about first Aboriginal, non-Aboriginal relationship.
Okay, so the question then is, what is the James Bay and Northern Quebec Agreement and the creation of Nunavut? How did that affect relationships between Indigenous peoples in Canada? Okay, so the James Bay and Northern Quebec Agreement came out of, it was the first modern day land claim. The historic treaties were negotiated until I think about 1930. It was Treaty 9 was the last one that was signed in Northern Ontario. For that period, since 1930, there were no agreements with the Crown in certain areas of the country, including British Columbia, parts of the territories, especially the Eastern Arctic. There were some treaties up into Northwest Territories and Yukon. I wish I had my map. And then Quebec, and there were peace and friendship treaties here in the Maritimes, but no ceding of land. So in 1973, and again subsequent to the Calder decision, the federal government brought in what was called a comprehensive land claims policy to begin the process of negotiating with Indigenous communities about the nature of their rights. There's been a huge amount of controversy and debate about that federal claims policy. And the major criticism of the policy from Indigenous peoples is that that policy requires Indigenous peoples to give up their rights. So the only rights that they have are then those that are defined within the agreement. And a lot of Indigenous communities believe that their rights are inherent rights. That is, they were granted by the Creator, they've always been there, they don't need to be recognized by the Government of Canada, and that the federal claims policy was actually undermining those rights. So there's a number of Indigenous communities that have chosen not to negotiate those modern day land claims. James Bay Cree did, and they're the first one in 1975. You would have to, I think that they would say that it was a flawed agreement, but it was the best that they could do, and it gave them some ammunition in their battle with the province of Quebec over hydro development. I know the agreement mainly through my work on forestry, and the Cree battled for years to get an extension of the agreement because initially it didn't cover forestry. And so there was other resource development going on in their territory that they were very unhappy with, including logging. And they threatened lawsuits against the companies and the province and brought them back to the table, and they managed to negotiate an addendum called the Peggy de Brave in 2002, I think it was. And that agreement gives them much more authority over forest management than they had before. So they continue to struggle to have their rights recognized, even though the agreement's in place. And I'm not one to judge whether it's a good agreement for them or not. That was their decision. They made it. They're, struggling with it. And the same with Nunavut. The Nunavut came out of the comprehensive claims in the Eastern Arctic. And their decision was to establish a separate territory. And so they've been raised up to the level of a territorial government now, which is a step above what any other Indigenous community has. I know they struggle still too with lack of funding and resources and people to do the work and all of those kinds of things, but yeah, as much as I can say. Yep.
I guess I'm trying to speak to this here, observation on the current system and how it's working.
Yep.
I've been part of the process here now for 7 months. I'm from Ilsibuktu, and I work for Gobit Lodge, and they're the ones who put the Aboriginal title forward. So we've been doing consultation about, for a little while now, and it took us, a couple of years to get the government to take us seriously. So, I can say, just from observing how the system works today, seems like bullshit. We try so hard to, our mandate is to protect the water and protect the environment. And then when we start going into how the government province wants us to engage, we're always looking at it like they're sending us so much things that we don't know what to engage on. And then we're all confused and we're all thinking oh my God, we don't have the resources to do any of this stuff. And then Chris, buddy here mentioned also, we did recognize that it's hard to have your say, because especially if you're coming from a grassroots. So we have that delegation consultation to us by the Bannon Council. So we can say that, Ilsibuktuk is a grassroots community, and, just coming from the shale gas protest. So, trying to go around that loophole Buddy was talking about, that's what we're trying to do. And then when all these consultations come forward, they come at us with everything. And then some of them don't even take you seriously. You called it a drive-by consultation. Bruce McIver is our lawyer, by the way. And that's exactly what the situation is. They're coming in, they just want to send you some stuff and letters to engage on some possible projects. And you're standing there what do I do? They don't want you to respond, first of all, because they'll have to start engaging with you. So we're handpicking what we would like to engage in because we're lacking the resources to engage in everything. So the problem is there, holy God, the government expects us to understand the environmental impact statement. I'm just like, whoa. So anyway, when someone does acknowledge, and then you are engaged, and then you finally decide, I want to do, I'm serious about this, this might affect the water, let's look into this, and then somebody will come in and explain their project to you, and then all of a sudden you're standing there what did they say, and then they expect you to be, I don't know, some sort of person that can talk to the ground or something, and expect you to be experts right away on the environment. So we're always standing there and we're trying to listen, and then, most of the time, we try to take steps where you try to say this is not consultation, but maybe just an info session. But most of the time, this development or this certain proponent or some changes in the legislative level, when it's all coming at you and you don't respond that moment, it's always like, you know, they don't even respond after. So you're just sitting there like, oh, there's another one that didn't take us seriously. Oh, there's another one. And then like, you know, I think, you know, I talked to a little bit of other people and other consultation coordinators, and they're going through the same thing. And that's right here in New Brunswick. So I don't know what's going on there, like from the difference from what you're talking about, but you know, the province here is a little bit different on how they treat their Aboriginal people, specifically on the natural resources and, you know, the forestry and the crown land. So, like, you know, I just wanted to provide a little bit feedback on this question here. So,
Well, thank you.
you know, and there's other people in here that can probably speak to that.
Are there, and including people for, is there anyone from the province of New Brunswick? I don't want to put you on the hot seat or anything. Careful. Yes?
I'm curious, perhaps you're familiar with this thing called the Sisson-Brook tungsten mine, which is, I think, potentially one of the next really big land disputes, shall we say, here in New Brunswick. And there's it's kind of touches on a few of the points the gentleman from Quebec mentioned regarding who speaks for the Aboriginal First Nations here in New Brunswick, the elected band council versus the traditional representatives, right? And the quick and dirty on our current situation is that there was a negotiation that was signed by the elected representatives, formal, that the province negotiates with, but it was on pain of having a tax. I mean, it was a really sneaky negotiation regarding taxation of, I think, gas or sales taxes on reserves. In that case, there was these two balancing issues. And, I mean, it speaks to a lot of what the gentleman mentioned there. And kind of, this is upcoming. And I don't expect you to have an answer for this, but this is just kind of, there's some really sneaky stuff going on, and it's just ridiculous. And it's going to be a big whoop-de-doo, I predict in the future. So, in any case, I don't know if anybody has something to say about that, but that to me is that to me is the most current, holy crap, what's going on here. And it's going to be pretty wild, I think. So,
Well, I go back to the Supreme Court of Canada principle that's been underlined ad nauseum in the cases that have come forward, and that is this principle of the honor of the Crown. And the Supreme Court takes that pretty seriously, that it has to be demonstrated that the Crown is acting in good faith. So if there is evidence of what's called shady dealings,
well, it's transparent, it's open, we all know it happened.
yeah.
And everybody says, yeah, okay, that's the deal, but that's the deal?
Hmm.
And there's these questions of legitimacy of these band, the elected band councils. If you spend any time on First Nation, well, I'll just speak for here in New Brunswick. It's an interesting, they've learned the divide and conquer party affiliation and flip-flop, and it's just, it's ridiculous. Sorry, pardon me if there's any.
I'm very careful about making judgments about how people, you know.
I'm not though.
Well, no, but yeah, there is a tendency, and there are people in Canada who have spent a lot of time trying to undermine the governance structures,
Yes.
even elected chief and council of
Yes.
First Nations across Canada, as a basis for arguing that we should get rid of First Nations, we should get rid of the Indian Act, we should get rid of reserves, we should privatize all the land, and it goes back to assimilation arguments. you should become like us. But, you know, one of the things I say is that a lot of times there's corruption everywhere, but it is not, it's, you know, it can be the one apple that spoils the barrel. To say that all First Nation communities are like that is I don't think it's helpful. And how we deal with that corruption, in fact, I don't think it's up to non-Indigenous peoples to deal with it. I think it's up to people in their own communities to figure that out. And lots of people are, particularly a lot of women are involved in making some of the men accountable for some of the things that they've done that are maybe not, whatever. So that, I think we simply need to acknowledge, yes, that is going on, but that doesn't detract from the fact that chiefs and councils are elected representing their communities, are accountable in some ways to those communities, and it's people in those communities that are going to hold them to task. Yeah.
The area that those chiefs and councils that are elected only cover the area within the reserve.
Yes.
Outside the reserve, they do not have that jurisdictional
Authority.
Stronghold.
Yep.
Whereas the original governance system has that. And you know, like this up my area, we have the 7th District Tribal Council. That is not government made. That's an original tribal council of one of the 7 districts, and we are the 7th District. Now, the government's tribal council is Listugush, I guess Peggy Gaspy. That, again, the government made that tribal council no different from what it made those chiefs and councils. So it's not original. Just like Canada making itself a country, when yet it's still a state. It's not really a country because you just put a pen and paper, well, okay, 1867, we're a country now. But the tribal council has that jurisdictional stronghold. We can go, and that's where they can challenge the province. They can challenge the federal government. And there's not a court that could say, you're not recognized, but they are recognized. It's just that these governments don't deal directly with an original tribal council or an original district chief. And I think that's where you find your kind of shady dealings, but it's not a shady dealing. It's just that's how the system works. So when you say, what are your observations how the current system is working? It only works for those that want something out of it. But it doesn't include the people. And that's the sad part about it.
Yes.
I just wanted to speak to the system line that this gentleman was speaking about. We're part of the Council of Canadians, and we work with the homestead people. And right now, there's grandmothers and mothers who are exercising their inherent right to live on the land where this tungsten mine supposedly will be built in the spring. And they're building tiny houses, but representatives from the government have been out to tell them they have to leave. Of course, these are very strong women. They're not leaving. And they just laugh. They built tiny houses on the tailings pond. So then they had carpenters out there working on the tiny houses. They told them they'll come out and confiscate their tools. So they just laugh. They're there for a long time. But they've been working other things.
Any other comments on how the system's currently working before we move on to the UN Declaration? Over here. Behind her.
I can't speak for the government of New Brunswick, but I did work for the Department of Natural Resources for 22 years. And that involvement ended 10 years ago. So my information's a little stale. But I, I started as a civil servant. I had very little engagement or understanding of about the communities, and I didn't know really Indigenous people at all. And I found that everybody who was around me seemed to be kind of in the same boat. And I had the opportunity later on to interact some with Indigenous people, and it was a great learning process. But I also encountered just in the halls at work, conversations and language that there's no other way to describe it than it was just racist, and blatantly so. And it was rather upsetting. But I think now, what's happening here in this room is a hopeful development. I think University of Brunswick, from the president on down, they're showing good leadership. But the only way that this relationship with the provincial government is going to change is if people like myself, the settler community, raises it as something that they want with their own representatives and their own government. And even once you've done that, it takes a long time for the civil servants to cycle through a bureaucracy. So, but it really, I sense that the responsibility is on the settler people to really let their wishes be known in this regard. And there's an election coming.
Yeah, we formed an organization in Northern Ontario called the Northern Ontario Sustainable Communities Partnership, and it was an organization to promote community forestry as an alternative form of tenure to our industrial licensing system. Anyway, one of the principles that we adopted was that we would work to help to resolve the issue of Indigenous, non-Indigenous relationships, and that we would work to protect Aboriginal and treaty rights. And we had a long conversation about that, about whether we would do this or not. And part of the conversation was, well, it's not up to us. The Supreme Court of Canada has said it's the Crown's responsibility. What does it have to do? There's nothing we can do. And it's like, these are our governments. We're the ones that have that responsibility. And if they're not acting in the way that we think they should be, then it's up to us to bring that forward.
I just want to add something real quick, that we're in an era of reconciliation, Bo, and I really think that something that we're overlooking is we're not, with those power structures and social arrangements that colonialism created for Canada are still in place, are still in power, and are still in control. And there's those power structures that we kind of overlook to make a lot of social arrangements. And deeply, I like this gentleman's comment here too about the role of settlers in reconciliation. And there's different levels. So Indigenous and settler societies, reconciliation, but a big part of reconciliation is settler society needs to decolonize their relationship with corporate Canada or their corporate influence over policy. And that's not just in the forestry. Our focus is on decolonizing education, but it's so systemic. Those colonial government relationships, and who gets to make powers provincially, federally, territorially, those social arrangements are still in place at every level of society and education and the economics and politics. So those are is it an ideology shift we're really working on? And those are some of the, when we talk about reconciliation, it is a huge intergenerational thing. And we don't even have a platform for reconciliation in New Brunswick the way that the social arrangements, the colonial relations are.
Yes.
Just to pick up on Chris's comments, when I look at the question, like, for me, the current system does not work for First Nations across the country. The consultation framework is put together by the Supreme Court of Canada is for the benefit of the colonizers, the the Crown and of course the corporations. The Crown, especially the Indigenous Affairs Department, their responsibility is to protect our interests. But they never, if anything, they protect the interests of the corporation and so on. So there's no honor of the Crown, as you mentioned earlier. There is dishonor of the Crown because of the way that they protect the corporations, protect their interests, and work against the interests of First Nations across the country. So here in New Brunswick, we haven't seen real consultation, because what happens is that they may have meetings with the chief and councils, like the gentleman from Nelson mentioned, but at the end of the day, they still impose their agenda on First Nations. So there's no meaningful consultations here, even though there's a framework, but that framework is for the benefit of the Crown and the corporations and not the First Nations.
Who's back here? Yeah.
This isn't to do with land claims so much as it is, last question. Sometimes you encounter sort of the racist view that all the First Nations or Aboriginal peoples are getting tax dollars. I recall several years ago seeing something that was a federal piece of legislation with the words royalties in it. And it spelled out the manner in which royalties were to be paid to Indigenous peoples. And to the best, I cannot find that legislation, and I was just wondering if you can tell me anything about it.
So the province, when they develop natural resources on provincial crown land, levy a royalty to private companies. So if you want access to minerals or forests, then you pay a royalty. All of those royalties go into provincial coffers. There are many First Nations that have asked for what's called revenue sharing, that they would get some kind of share of those revenues because those resources are coming from Indigenous territories. And a lot of people are in communities where they'll complain about the fact that, 50 logging trucks went through our community today. We don't see any of the benefit from that. What we get is the environmental damage that's left behind. So there is discussion going on in some parts of the country about revenue sharing. The James Bay and Northern Quebec Agreement, the Pays de Brave, the addendum that I was talking about, they negotiated, I think it's $50 million a year over the next 50 years from revenues from forestry, mining, and hydro development. And that's going to 9 First Nation communities that are part of the James Bay Cree area. There's been some revenue sharing in British Columbia through the province giving a portion, so many cubic meters, or so many dollars per cubic meters to First Nations. It's not a huge amount, but it is some. And are you still getting your revenue sharing here in New Brunswick? Yes?
Revenue sharing, no.
Yeah, because at one point it was 5% of the allowable cut, and that happened after the Paul decision. Challenging, the Mi'kmaq challenging the provinces or harvesting timber on Crown land without a license and getting charged. That was a watershed moment here because prior to that point, the province of New Brunswick didn't pay any attention to First Nations. They were a federal responsibility, and so they were not considered to be part of any of the provincial management systems. But after that case, things changed. So are you still getting that 5%?
With regard to the annual allowable cut, it's still there, but it's distributed amongst the communities. And then from the communities, they take that and then they can do whatever they feel fit with it.
Okay.
Some communities, they contract it out and get royalties that way.
I would say that highlights a lot of the problem that we're alluding to, that Bo points out. The band councils may be getting that, but the knowledge doesn't filter down to the communities and all the communities. There are some First Nation, like Indian Act governments that work, chiefs and councils that do work for the people, but I know from my community, and I've experienced with a lot of my friends, is information gets to the executive council of the First Nation community, but it never trickles down to the people, the citizens.
And I think that's a misnomer when we're talking about millions and millions of dollars. And general Canadians think that Indigenous people actually get to receive this money, and that's just not the case. And when we're talking about the behind the scenes kind of dirty little secrets that are going on, our communities are so strapped for cash, and there's so much poverty in our communities that the government makes deals with each individual community. So one community might get treated differently based on what resource area they sort of control because of their position. So then you have infighting between the communities and the chiefs, and that's what causes a lot of the discord in our communities. And so when the money comes down to the people, they might get $100 a year. So the $50 million does not translate into lots of money for Indigenous people, because that's just not the case.
Yeah, the 50 million I was referring to was for
Yeah.
Quebec, not New Brunswick.
But even $1 million sounds like a lot of money to some people, and it's not.
What was the consultation and the number crunching and the negotiations that went into the determination of 5% royalties? I mean, obviously it was not a big news day or whatever. I mean, that 5%, anyway, carry on. Just a comment.
No, you'll have to ask locally about that history. I wasn't here, I wasn't part of the negotiations, so I have no idea how they came to that.
To this gentleman's point, this is part of that whole, here's your 5%, enjoy. What? I mean, that's just insanity. Anyway.
On the other hand, it was an acknowledgement that the First Nations did deserve a share of benefits. Whether it was enough or not is another issue, but that acknowledgement was a step forward.
Well, it makes sense to be 95%.
Yeah.
And then 5%. Since we're talking 1725, how come everything has to just go, whoa, hold it, let's sort this thing out before we go any further. I mean, let's stop. I mean, seriously, stop the whole show and let's sort this out. Seriously, just turn them off, because there's only, there used to be, I don't know how many, 10,000 people working in the woods, and now there's 100 with feller bunchers, and so there's 100 guys sitting around for a couple of months. What would be so wrong with that? Anyway, I'm just attempting to be funny. Ha ha ha, it's not that funny.
Okay.
So,
Okay, we'll have one more question.
About New Brunswick, because coming from Ontario, here we have the disadvantage to be in a feudal system. On the economical point of view, led by one company, Irving. So the problem, we do not have the advantage of the feudal system, because if we would have a middle-age system here, every revenue from the natural resource will come directly to the community. So like I'm coming from Belgium, and in Belgium, the natural resource is owned by the city. It's not owned by the province, because we have experienced the middle age. Here, unfortunately, in Canada, we never get this middle age period when we create a strong community, city-type society. And so we have the disadvantage of having the bad part of the feudal system without the advantage of having a true feudal system, when all the economical benefit come back to the community. The problem of the First Nation here, the poverty of the First Nation, is also the same things with the white people. If you take a car and go in the wood here, you will see so many abandoned houses, very poor people, and they are close to richness, because the richness is in Bermuda, not in New Brunswick. So this is a particular problem here for New Brunswick, this Irving system, but also the fact that we fundamentally, as long as Fredericton is managing all the land of New Brunswick, we will continue to have this problem of lack of regional development in New Brunswick, and also in Ontario and in all of this.
Thanks. Okay, couple more, and then we're going to move on. Yes? Yes? Oh, you don't have a question? Sure.
Situation, over many years of seeing what's been going on back seems to me that the situation is impossible. It sort of bogged it down in so much bureaucracy, et cetera, but despite, the Supreme Court's recognition of Aboriginal rights and, they have access to resources, et cetera, every time something comes up, they have to drag it into court to get it recognized every time there's some infringement. But they don't have the financial resources to do that. So, and then if I look at just generally for the rest of us, white guys, so to speak, it's the same situation. We have a Charter of Rights and Freedoms, but if I want those recognized, it's not like they're there and up front. I have to drag somebody into court to get them recognized. I'm in an impossible situation because I don't have the financial resources for it. So it would seem to me that in a bigger sort of, if there is to be justice in some sense, then those resources should be there automatically for the Native communities to have their rights recognized, and it shouldn't be a burden upon them. They're the ones with the original rights. It's the other guys who have come along and said, well, you've got to prove those rights. They've set the standard. Where in fact, Natives have that right, period. And it should be up to the invader person infringing upon those to, come up with some proof that they're not doing it or whatever. So, until something like that happens, it's virtually impossible to, your thoughts about that?
I don't disagree with you. I think that's, and moving on, to talk about the UN Declaration on the Rights of Indigenous Peoples, the question about whether that's a way forward or not, my thoughts are that it isn't much of a way forward, but I'd like to talk about that a little bit and just be aware of what's in it and whether it carries more weight or should carry more weight than our Supreme Court of Canada decisions, or whether it's going to help resolve some of these issues. So, but first, I just wanted to give an Indigenous perspective of Aboriginal rights and title, and to bring in the concept of self-determination, because that's the one thing when we're talking about consultation, and even when we're talking about consent, it is usually a process whereby Indigenous peoples are having to respond to somebody else's ideas about how resources should be managed and developed. So you can comment on, you can consent to what we have decided is the way to develop our resources. And to me, self-determination is the ability of Indigenous peoples to decide for themselves how they want to be responsible for their territories. So, and the territory is defined very differently from the Crown. So we know, in Canada we talk about property rights. We have federal government ownership over certain lands, a huge area of land that's owned by the provincial crowns, the majority of land, and then we have private land. That is not the way that Indigenous people look at land. Land is a gift from the Creator. It is not something that you put boundaries around and parcel up and hand out to individual people for their own profit and gain. So, and there is also this sense that has been disrupted because of colonization, and that is the sense of responsibility that Indigenous peoples feel and acknowledge that they have to look after that land. Many Indigenous peoples will say, traditional people say, we were put here to look after Mother Earth. That's our job. And what is the implications of removing that responsibility by removing people from the land over generations, there's no wonder that there's the kind of dysfunction that we see in Indigenous communities. So and those rights and responsibilities to look after that land isn't subject to the approval or the acknowledgement of a foreign power. It's not up to the Government of Canada or the Province of New Brunswick or the Province of Ontario to say, oh yes, you have that responsibility, you have those rights. Those are inherent rights. And that is a sovereign right to rule the territories. So these are principles that come from the Union of BC Indian Chiefs, but it's not unique to the Union. There are many other Indigenous groups that have said the same things. So they declare that they have sovereign right to their territories, and that is supreme power over those territories, resources, and lives, with the right to govern, make and enforce laws, decide citizenship, wage war or make peace, manage lands, resources, and institutions. That's what self-government and self-determination is about. And of course, that's something that people aspire to and they try to assert, but in the middle of our colonial system, which has essentially had the target of removing people from those responsibilities, that isn't happening. So let's look at the UN Declaration. So this UN Declaration has been in the works for a long time. Started in 1984 with a working group on Indigenous populations. So it's taken over 20 years to draft the UN Declaration. And from the beginning, Indigenous peoples were involved in the drafting of the UN Declaration. So in 1989, the International Labour Organization Convention 169 came up with a document concerning Indigenous and tribal peoples in independent countries, acknowledging their right to self-determination within nation states. So we're not unique in Canada. What's happened with Indigenous peoples around the world has been similar. Colonization has meant that people have been removed from their territories, and a system of governance by a nation state imposed on them. So Indigenous communities around the world are all living within nation states. And it was the ILO Convention 169 that brought in this concept of free, prior, and informed consent. It was around resettlement, and so it was that no Indigenous community should be resettled, and there was a lot of that going on here and around the world in order to access settlement lands or lands for settlers and resource development. And so FPIC was required for any resettlement. Canada did not sign ILO Convention 169. They still have not signed it. In 1994, the first draft of the UN Declaration was approved. And then in 95, there was an intersessional working group set up to work on refining the draft. That working group spent 11 years revising the draft. So in 2006, the UN Human Rights Council approved the draft declaration, and it was passed in 2007 in the United Nations General Assembly. 144 nation states were in favor, and there were 4 opposed: Australia, Canada, New Zealand, and the United States. And the general argument from those 4 countries for not approving the declaration was that it would undermine the national law that was sufficient to deal with Indigenous rights already. They didn't need an international body coming and telling them how to look after their Indigenous peoples. So with pressure over time, all of those countries are now endorsing the UN Declaration. So in 2010, Canada under Harper issued a statement of support. So it wasn't a complete ratification of the declaration, but it was a statement of support, which was more than they had done previously. Then in 2015, under Trudeau, Canada has promised to fully support and implement UNDRIP, and there is a lot of activity now going on around what that means, and a lot of confusing activity by the federal government about what that means. So some people have called the UN Declaration on the Rights of Indigenous Peoples a monumental document because it was created at the international level with rights holders themselves, with Indigenous peoples. But there is another school that says, now this is just a toothless tagger, and there are a lot of people who think the UN in general is toothless, but it is not legally binding on any country. So there are no repercussions even if a country ratifies the UN Declaration and they're found then to be in violation of it, there's no penalties. You can't levy a fine, you can't throw anyone in jail, and so people call this soft law, and that it isn't legally binding, and therefore it doesn't mean much. It's also, the other criticism of the United Nations is that it's built on the premise of national sovereignty. That is the sovereignty of the nation state. And those nation states who are members are, the highest level. So it's the country of Canada. And there are some Indigenous groups that have standing at the United Nations, but not as independent nations. So this idea of the nation state being the ultimate authority, and everything has to be then interpreted through national laws, which is what is going on now in this country. Both federally and in some provinces, there is a review of laws as they relate to the UN Declaration to see if they're in compliance with it. And what's happening in a lot of the provinces and federally, there are a lot of people who have said already our current system of consultation is sufficient to meet the UN Declaration. So, the Declaration acknowledges Indigenous rights to self-determination and Indigenous institutions, to life, integrity, and security, to culture, religious, and linguistic identity, to education, public information, and employment, to participation in decision-making, and this principle of free, prior, and informed consent. It acknowledges rights, economic and social rights, and rights to lands, territories, and resources. So there are a number of articles that do have an impact on resource development, but I think Article 32 is the one that's key, and that is Indigenous peoples have the right to determine and develop priorities and strategies for development or use of their lands or territories and other resources. And secondly, states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions to obtain their free, prior, and informed consent, free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. And thirdly, states shall provide effective mechanisms for just and fair redress for any such activities, and appropriate measures shall be taken to mitigate adverse environmental, economic, social, cultural, or spiritual impacts. So on its own, Article 32 has very strong language, but again, the crux will be in the interpretation of what this means and how it's going to be applied. So I'm not going to spend a lot of time on this. I think it's fairly obvious that the principles are free, that is given without coercion, consent is given without coercion, that has to happen before any development occurs, that sufficient information, similar to what we saw as a principle of meaningful consultation in Canada, has to occur. And finally, the one thing that's different is the consent, and that is the option of supporting or rejecting development that has significant impacts on Aboriginal lands or culture. So there is growing support for this idea of FPIC and moving beyond what we might call drive-by consultation, or a consultation system that's in place right now that obviously a lot of people are frustrated with. And across Canada, it's similar. Indigenous peoples have expressed over and over again their frustration with provincial consultation processes and the interpretation of the duty to consult and accommodate. And in that process, unless, again, remembering going back to Delgamuukw, unless the infringement is severe and the strength of claim is strong, consent is not required in consultation processes in Canada. And the onus on Indigenous peoples is to prove the infringement of rights. And so rather than on the developers or the province that issues the permissions and the licenses. That there's a failure to substantially address Indigenous concerns. So is free, prior, and informed consent going to be a way to strengthen negotiations between provinces and Indigenous peoples? With this growing support, we see some of the private sector through their corporate social responsibility documents supporting the principle of FPIC. We had the International Finance Corporation Performance Standards, the Forest Stewardship Council, International Council on Mining and Metals, the Boreal Leadership Council. So there is some significant private sector support for the idea of FPIC. And then again, as I mentioned in the Tsilhqot'in decision in 2014, the Supreme Court acknowledged that when Aboriginal title is proven, consent is required. However, we only have one First Nation in Canada where the Aboriginal title has been proven in court. So Trudeau has said Canada will implement UNDRIP, but has also said our current laws are adequate, and has also said we'll review the laws. So those things are going on in process, and how they're going to come out in the wash is anybody's guess, I guess. Alberta was the first province to commit to review all of its laws and policies in light of UNDRIP. And they had a deadline of February the 1st, 2016 to do that. They still have not completed that review, and they've been pretty silent since this particular quote, which was September the 16th, 2015 from the Premier Notley. It's not something that's happening overnight, she says. We sent a letter to ministers about UNDRIP to evaluate the work that they do and come back to us to report on what's already aligned, what can be improved, and whether there are problem areas that are potentially in conflict. But there's been nothing conclusive from them about the results of that review. So that's the big question. Is FPIC a step forward? Is it a step towards reconciliation and self-determination? Given, I think, some of the comments that we've had tonight, that we can conclude it might take a lot more than the UN declaration to move our governments to truly start on a new path of reconciliation with Indigenous communities. And while I think the FPIC might be a step forward, it's certainly going to help to maybe raise the level of dialogue somewhat and shine a light on our existing consultation processes, but I don't think that it's going to be the solution. On that sour note, I'll end.
So do you want to take more questions?
I'm game if people.
Thanks everybody for hanging in.
Yeah. And I have no idea how long that lasted.
8:48.
That's okay. That's not bad. Yes, open for comments. Will FPIC save us? Well, I've espoused a model of what I call co-management as co-determination, and that is having the government acknowledge that Indigenous peoples are self-determining and having kind of negotiations based on equal standing at the table, rather than, you know, Indigenous communities being seen as individually being required to consult on projects that somebody else has already decided on. I think it means really raising Indigenous communities up. And in doing that, you know, I also acknowledge that Indigenous communities are going to have a lot of work to do in order to find that new way, because we're so trapped in the colonial system we've talked about, in the Indian Act, and you know, this 200 years of this relationship. But to go back to, I think we have some really good direction with the Royal Commission on Aboriginal Peoples. Their final report came out in 1996, and then it was shelved. There was a response from the federal government, but really nothing much was done with the recommendations. And you know, that commission took 5 years, and there's 5 volumes relating to everything from justice to natural resources management that are covered in there. And now we also have some further direction from the Truth and Reconciliation Commission as well. I think some of the steps, I mean, we're all struggling with that. I know at Lakehead University, we started looking at indigenizing the curriculum. You know, what role can we play in improving people's understanding about the impacts of colonization on Indigenous peoples, and where do we need to go from here? And it's hard to do in a colonial institution like a university, but yeah, there's lots of that going on across the country in different places. And I think I like what people said earlier about, you know, it's up to us. It's up to us to get together and try and figure these things out. And I mean, we have roles to play in Indigenous communities, in making those communities more functional, and figuring out a strategic approach about where we want to go. And settlers have a role as allies in supporting those communities, and sounds like some of you are doing that already. So we just need, I think we need to keep that work up and recognize how important it is, and not, you know, have the, sometimes I think the TRC has been a flash in the pan, you know, and then we're all going to get over it and forget about all that discussion, and we'll move on, and things will kind of fall back to where they used to be. But so I think we need to keep the dialogue going. Yep.
In Brunswick, we have a Peace and Friendship Alliance between non-Indigenous and Indigenous people, and we meet every few months, and we work together on various issues. And if anyone's interested, the grandmothers that are at Sisson, right now, they have a Facebook page called Connecting to the Land. And if you want to go there, right now they're having an auction of Valentine auction to help them raise money for supplies so they can continue to stay there to protect the water for all our areas. Connecting to the Land Facebook page. Check it out.
Thank you. Yep.
I just wanted to say too, it's kind of an important thing to note that under the current framework, the duty to consult doesn't actually work backwards. It only works for kind of things happening kind of right now. And I'm the consultation coordinator for St. Mary's First Nation, and there was only a consultation department established, and it was only one person back in 2012. So anything prior to that, there was no duty to consult or accommodate. It's just an important thing to know.
Yes, very true. And I know in Ontario, I mean, it was Mikisew in 2005 that triggered the province of Ontario to finally come up with a draft consultation policy. Prior to that, there was nothing. So, yeah. Yes?
I was going to get you to comment on your Northern Ontario Sustainable Partners.
Communities Partnership?
Well, yeah, but I'm going to pass on that one, if you want to talk about that.
No.
But I have a theory that the quickest way to get this stuff addressed Look, we get out there, protest, occupy, all that stuff. But it's my theory that the quickest way to get these policies and laws addressed is through the changing, not so much the, well, it's great to change the political system, but the best we have, the next step in changing the political system is through the voting system. And everybody says, oh, geez, not this guy again. He's going to mention proportional representation. Proportional representation? Because my theory is that our current system stifles the free speech of politicians, and that they can't really address these issues without fear of alienating people in their riding, which means there's no way that they will ever get elected. Okay, my theory is proportional representation eliminates that gag on people's political free speech when they're discussing these things on the campaign trail, which means that if we have more voices in the legislatures addressing these policy discussions and being commented on in the media, it's the quickest way, in my opinion, unless somebody wants to suggest another way, other than blowing the place up. This is the only way, or it's the quickest way to get these things addressed at a higher level. And I'm curious if you had any thoughts on that.
Yeah, I'm in favor of proportional representation, and I think our political system is broken and it needs to be fixed, and I think that's one of the important areas to work on. And there was great hope. We had a promise that we were going to get proportional representation. Yeah.
I guess, yeah, another thing I'll talk about too is kind of how my experience has been so far with dealing with the province consultation files. They're dealt with on a project-by-project basis, and cumulative effects aren't really taken into account. And it's just a frustration I have is file between file over the same type of industry, whether it's fisheries or forestry. Cumulative impacts just aren't considered when you're assessing impact. It's project by project.
Yeah, if you have some avenue to bring that up through the tribal council or through a broader, group, a First Nation organization, I think that's really a worthwhile thing to push. And I mean, I taught environmental assessment, and that, it's been a major thing in Canada is to deal with cumulative impacts. And there's all kinds of great ideas, and it's been proposed for years, but it is still not being done. And it makes so much sense and coming from Northern Ontario, we have the Ring of Fire in the north that's going to be affecting Matawa First Nation communities, all Indigenous communities in the James Bay lowlands. And that's what they want, is a comprehensive environmental assessment that deals with cumulative impacts. It's not just impacts on the water, and it's not, you have to do it with cumulative impacts. And if you're that responsibility of looking after the land, I don't know how else you can do it do it well if you don't address them. So find a way.
Okay. Well, thanks again, everybody, for coming. Let's give everyone a round.